going to have to explain to me or show me why you should not have it available now.
So I told him last night what I needed, and he's not retrieved it. And I asked, we gave it, it was part of our evidence we gave to the state, and Tommy says he doesn't have it.
Well, we'll just deal with that when it comes up, but I'm not going to stop the proceedings to wait for you to get the document. We'll deal with it as it arises.
Judge, I'll say this about the copy I was provided. It was one page, and it was the copy that I was given was virtually illegible, and I had no value to me.
What was the document, Mr. Brown?
It's a bank statement.
One page on a bank statement.
Yeah.
Also, I couldn't understand the relevancy of it. I couldn't tell what it was.
Well, state into the record, Mr. Brown, at the podium what the document is and what the relevance of the document is.
The document was the bank statement for September of 2001 from my escrow account, and it would show that the balance on that statement for the prior month would have been less than $500. The relevance is, in this case, the check that was written for $250,000 came off of that deposits that were made after the beginning of that month. And therefore, by the argument the state's making that $1 million, that $250,000 came from that $1 million is incorrect, and that bank statement shows it.
Well, say that to me one more time.
The state's case is this. The state's case is, and I'll go through what I do, Mr. Rogers. The state's case is making that $1 million was deposited, and these checks were written off it. Therefore, I've committed a violation of the investment statute. Okay, the $250,000 check was not money that came off of that $1 million at all. Not at all. It was money that I had deposited in that account, money I had.
Well, my question is this. In September of 2001, are you saying that the $1 million check had already been deposited into the account?
No, I'm not. I'll go through that with the witness. What I'm saying is the state has made an argument that $250,000 check, that's what the basic of the thing is, the $250,000 check has come off of that money. Now, when I look at Mr. Walker and go through this stuff, to show that, you'll see what the document is pertinent in regards to showing that.
All right, here's what's going to happen. In my view, you've had ample time to deal with that. Whether you've lost the document, not lost the document, that's up to you. At the end of the day, we'll go through cross-examination with Paul Rogers. You need to complete your examination with Paul Rogers. Now, if subsequent to him leaving the stand, you obtain that document, and you can show me whether there's a legitimate cause or need to recall him for that sole purpose, then I'll consider it at that time. But we're going to go forward with cross-examination of Paul Rogers at this point, so you need to complete everything except that.
Right, and I can set it up to that so that if you find the document, you'll see where it falls in line.
I'm not saying that I'm going to allow you to do it, but if I do, it will be limited to that. So everything else that you need to do with Mr. Rogers, you need to do with him while he's on the stand.
Okay, thank you.
All right, I've got the defense instructions that have been filed now. So anything else we need to take up before we bring in the jury? Anything from state?
Judge, can we get a copy of your instructions, please?
I assume that they got your copies. All right, anything else from the state before we begin?
No, sir.
Anything else from the feds? All right, let's get Paul Rogers back in on the stand before we bring the jury in.
Can I see the exhibits, Sean?
Good morning, ladies and gentlemen. Assuming that you all had a good rest and you're ready to go for the day. Is that right? You've all followed my admonitions. No one's discussed this case with anybody. You've not done any research or anything of that nature. Is that correct? All right. We're going to resume cross-examination here, or begin cross-examination. Mr. Rogers, you're still under oath. Cross-examination by the defense. May proceed.
Morning, Mr. Rogers.
Morning.
You know the way back, don't you?
I've known you for quite a few years, yes, sir.
And yesterday we were doing some stuff. I asked you a question about you were aware that you were being investigated for mortgage fraud, correct?
And
Good approach.
Go to the bench. May proceed.
Mr. Rogers, did you answer the question?
would you repeat the question?
Were you aware that you were being investigated by the Internal Revenue Service by Agent Phil Hall for possibly committing mortgage fraud?
I was not aware of that. That's, in fact, when you uttered that yesterday, that's the first time I've ever heard mention of that.
Let's move on. You and I had mutual clients, correct, in the past?
You mean we both represented the same client?
Well, yes.
I can recall on one occasion where I represented a client and you later assumed the representation of that client. We didn't work on anything together.
Okay. And you were fired because you made inappropriate remarks to the other people, correct?
Sustained.
Okay. Can I ask, was you fired?
No, it was objected and I sustained objection.
And I also asked the council to be admonished. He knows better than that.
Council approach.
It would be fair to say you upset that you lost them as clients, correct?
Not at all.
They were fairly large client you, weren't you?
Not, I mean, they built swimming pools, and I had represented them on 2 or 3 matters, as I recall.
But after I took over, you no longer represented them again, correct?
That is correct.
Okay, let's move on. Okay, I need to... If I can approach the witness in your honor. This is Creed Morris. It's State Exhibit 1. You're familiar with that document, correct?
Yes, sir.
Okay, and that document, that shows 5 checks that I received from me and Thomas from letting receive.
It shows a check that was payable jointly to you and Thomas McClinton that was endorsed, that was both made out to Thomas McClinton, signed by Thomas McClinton, endorsed by Thomas McClinton, and went into your escrow account. Then the check for $1 million that was not payable, it was payable to Guardian of Divine McClinton, that was deposited into your escrow account. The check for $205,020.81 also payable to the guardian of Jemima Clinton, deposited to your escrow account, and a final check, $32,725, payable to the guardian of Jemima Clinton that was deposited into your Trustmark National Bank escrow account.
I was asking you, that's 5 checks, correct?
4 checks.
4. Not 5 checks?
The bottom mentions the 5th check that we were never able to account for.
Well, let's talk about that. You did an extensive background on that 5th check, correct?
I would not call it extensive. It came to my attention in review of the files in Cahoma County, Clarksdale. It came to my attention that that check had been sent to you, and I never was able to actually lay my eyes on that check to see where it was, how it was endorsed and where it was deposited. But since it came into your hands, I concluded that you were responsible for that. The amount of money in relation to the amount concerned was not so large that I took any additional steps.
But what I'm saying is, when you did a special master's report, it would be a fair statement to say that you were trying to be as thorough as possible.
Absolutely.
Okay. And so, in essence, you talked to all the people that were party to this stuff, correct?
I don't know who all the people that were party to this stuff means.
Did you talk to Thomas McClinton?
I did not speak with Thomas McClinton that I recall. I spoke with his attorney and I listened to his testimony in court. And I was given the opportunity to question Mr. McClinton and didn't feel the need to do so.
Okay, so you listened to his testimony in court, correct?
Yes.
Okay. It's the transcript. First of all, who's on the stand? Who can ask questions?
It indicates that Thomas McClinton is being questioned by you.
Okay. If you'll look at this is the documents that take you review, correct?
I'm just seeing those 2 pages. I can't respond to that.
Looking at you take it. This is the transcript for what you're done. You take it. This is the transcript from the court proceeding in Hinds County.
If you'd show it to me, I would be able to tell you. That's what this document states that it is, and the pages that you're holding in your hand have been removed from this. I take it that that's what this is.
What was the date of that transcript?
Transcript is hearing on April 4, 2011, hearing February 1st, 2012, hearing February 7th, 2012, and hearing on April 10th,
And I don't know if I was present for all those hearings or not. I probably was, but I can't say for certain.
Yesterday, you told Jerry in your special master report, you said that I was responsible for that clear check, correct?
That was my conclusion based on the information I saw.
Based on the thorough investigation, correct?
I said, based on the information that I saw concerning that particular check, that was my conclusion.
Okay. I want you to read. Line 23 through second page.
Excuse me, Your Honor. Could I have a minute to find that particular page of the transcript?
Don't approach me, please. All right, Mr. Brown.
For the record, Your Honor, tell me to find it.
Y'all will go ahead.
Identify by page number.
For the record, Your Honor, it would be the February 1 hearing is in the transfer report over Hines. It would be pages 40 to 41. Uh, Twenty-two on page 42, A to line 2 on page 41. That's what you're okay. If you were going to ask questions, you answer me, questions by me, and answers by Mr. McClellan.
Your Honor, I'm going to object you to cross-examine this witness concerning another person's statement.
That objection sustained, you may ask a question, and we'll see what we do.
Okay, Your Honor. You reviewed all the documents that you had before you, including the transcripts of the hearing February 1st, correct?
I never reviewed the transcripts, no, sir.
This is the testimony, correct? You testified to that.
I've said that I was probably present.
Okay. No, actually, like you said, you reviewed the transcript and you reviewed the testimony from the hearings, correct?
I don't recall saying that.
Were you aware that the third check was given to Thomas McClinton?
I don't recall if I was aware of that at that time or not.
Were you aware that in the conversation that on cross-examination of Thomas McClinton on a document or something you testified to that you reviewed, that he was asked about the 3 checks, including the third one, and he said that he gave it to his son?
Same objection, Your Honor.
I do not recall that testimony. You showed it to me. That's what it says. I did not consider the $5,000 check to be material in the less than 1%. So I saw the check, I made my comments, and I moved on.
Well, you accused me of fraud in the check.
Is there a question?
So, in your opinion, the check is irrelevant, is that what you're saying? You're saying that are you saying that I had the check, or are you saying you knew somebody else had the check and you didn't care because it was so little bit of amount of money, you were just going to throw it at my feet? Is that what you're telling this court? Is that what you're telling this jury?
There's an exhibit that I would like to refer to, if I could, Your Honor. It's the one, the letter concerning the check that he's asking me about.
I know right where it is, Judge.
Just a second, Mr. Brown. Let's take the 18 times.
Says 36.
Yes, sir, that would be Exhibit 6. The amount of this check, $5,290.43,
3 cents, was not included in my reconciliation of amounts that went into your client trust account and for which you became responsible. I know I made mention of this somewhat as a footnote to simply say, Mr. Brown got this check and I don't know where it went. I didn't feel it necessary to go any further on that. These checks were 9 years old at the time that I was engaged to do this, and I had already learned that checks were not available over 7 years old. So, like I said, I accepted it for what it said. It came into your hands, and where it went, it was your responsibility to establish that to the court, not mine.
Well, the fact of the matter is I gave the check to Thomas Clinton, correct?
I have no idea whether you did or not.
Would this document not say that?
The document says Mr. McClinton says that. That may well be true.
And the document also says that he gave the check to his son, correct?
That may well be true as well, but I don't know. And I didn't do any further investigation of that check.
So you didn't do it. So you tell the jury you did a very thorough investigation. I'm just telling the jury.
I was satisfied with. I did an extremely thorough investigation regarding the money that went into your trust account, how much came in and how much went out. But that $5,000 was not included in my.
Okay. Since you like to throw stuff like that, is my another exhibit, the Market State Exhibit 2. You know what check that is?
That's the check payable to Thomas McClinton, guardian of Devine McClinton, a minor, and Michael Brown, his attorney, for $1 million that went into your client trust account.
Tell me about that. Is that the check you were basing all your information on? Is that the copy of the check you're doing?
I don't recall.
Okay. Did you ever see another check, or that check, an original of that check? Did you ever see that?
I don't recall whether I ever saw another copy. I don't believe I saw the original. This was a Union Planters Bank, the check that was like 11 years old at the time.
Okay. You have no knowledge, that that check was ever deposited, did you?
I saw evidence. I saw other evidence that it was.
What other evidence?
Well, the disbursement of the.
Now, I asked
Wait,
you.
please. Counsel, let him finish his answer, and you can ask him another question.
The disbursement of the funds what I did see were the checks from your client trust account, the original checks that you wrote, and I don't remember whether I saw a bank statement or what other evidence I saw, but I was satisfied this $1 million went into your client trust account.
Okay, you're pretty familiar because you actually being CPA. You know the codes when a check is gone through, don't you?
I know that they put numbers and transaction receipts on checks. I don't know what they mean.
You don't know anything about, you could sit there for how long, 30 years, something like that?
I don't know what the internal routing, I know they're routing numbers, account numbers, but decoding them, no, I don't know what they mean.
Based on this check here, do you know if this check has any evidence that shows that it went through the bank?
This particular exhibit that you're handing me does not reflect that it was negotiated.
In fact, you've never seen a check or a bank statement that shows that $1 million ever was deposited, do you?
I can't say that for certain.
Well, then tell me where you got the information, because we're all looking for it.
It was probably, this was written on the Rebecca Henry estate account, and I feel fairly confident that the original of this was included in the estate file in Cahoma County. Mr. Ross was very thorough, and again, I think that the original of that I probably saw in the file.
Got it. I know what it is.
You bet.
Do you know what that is?
Says it's my report.
Very thorough report, correct?
I think so, yes.
Find that bank statement for me.
I don't believe the bank statement is. I didn't include bank statements in my
You did?
report.
See that second.
Mr. Brown,
Let me.
hang on both of them. Again, court report can only take down one at a time. Ask a question, they didn't finish answering it, and then ask another. All right? Have you finished your answer, Mr. Ross?
Now I'm looking at the document that he handed me. There are some bank statements in my report.
So just go ahead and show your
Hang on just a second. He's not finished his answer.
There are some bank statements in my report, but none that relate to the account on which that check was drawn. There is an accounting by Mr. Ross that was filed in the Rebecca Henry estate that reflects and reconciles, including that $1 million check. It's included in Mr. Ross's accounting, reflects that a check was written on 2/20/01 to Devon McClinton, partial distribution $1 million.
Does this show that that check cleared?
There was no, when the account was closed and the final distribution paid out, that check had been paid.
Well, how do you know that?
It's just one of those things that you
No, it's not one of those things. Once you tell me, how do you know that?
just, Because I do. I mean, it's just one of those things, based on experience and the understanding of these transactions, if that check had not cleared when Mr. Ross wrote the final check to close out the estate account, there would have been $1 million extra sitting there.
It's just like you knew there was no bank statements in this report that you written. Is that correct? And I just told the jury that. Is that correct? This is the report's report.
Court, please. Back up to the podium. You can answer the question if you can.
I can't answer that. I don't understand it.
All right, next question.
Do you understand that you just told this jury that there was no bank statements in this report, correct?
I may have said words to that effect, indicating statements relating to the $1 million check that we were talking about.
No. The question was asked and answered, said, do you want me to have the reporter read it back? You said there was no bank statements in your report.
What I said, I may have said that, Mr. Brown. I'm not denying having said that. Then I looked at the report and I corrected my testimony.
And this is the report you wrote, right?
It is.
Okay. There is still no proof that you have any knowledge that Exhibit 2 was ever cashed, do you?
We're going to object to the repetition. He's been over and
Overruled.
I am absolutely 100% convinced and satisfied that that check cleared the estate bank account that was being overseen by Mr. Ross, the attorney in Clarksdale.
When did it clear?
I can't tell you from looking at it when it cleared.
Okay. I'll hand you back to the first witness on it.
You may.
The February 20th, correct? And you said the state Exhibit 1.
That's what it states, February 20, 2001.
Okay. Based on Exhibit 2, say Exhibit 2, you don't have any, you basically are assuming that this check cleared based on the final disposition status from Mr. Ross, correct?
That and other things that I saw.
But you have no other idea of what day it cleared, do you?
I have some idea within a range.
Kind of like, you know, you had no bank statements in here too, right?
Sorry, is that a question?
Well, the question is going to be this. And you say Exhibit 9. What's that?
That is a copy of a check from the Michael J. Brown Attorney at Law escrow account payable to Linus Shackelford and Commemorative Properties for $300,000,
Okay.
indicating that it was a loan from DBM LLC at 10% for 3 years.
Did that check go through?
Your escrow account?
No, did it go through? Is there routing instructions in there?
I don't know. I mean, there's information stamped on the back that indicate.
Fine. You know,
Hang on just a second. You ask him a question, he gets to answer the question, and you can ask another one.
There's information on the back that indicates the check was negotiated.
that's not, okay, but we're trying to see a routing instruction there that shows the amount of check back cash for and cleared for, correct? Lower right-hand corner of the check tells you.
I see the number. Yes,
And it says $300,000, correct?
correct.
Right, that's not on, in fact, if you look on State Exhibit 1, look on State Exhibit 1, there we so you have no idea on State Exhibit 2 if the check cleared. You don't even want a bank account on it, do you?
I did.
You do?
It went into your attorney escrow account at Trustmark Bank.
How do you know that?
By the information that I gathered through my process of reviewing and examining the relevant documentation.
Well, tell me what you have that shows that.
I have the checks that were written on.
No, Mr. Rogers, I'm asking.
All right,
He's not answering the
hang
question.
on just a second. He may not answer the question the way that you want him to, but he can answer the question, and then if you don't like his answer, you can ask another question. But don't interrupt his answer.
It would be better if I could look at a couple of exhibits to the summary of the checks that were introduced into evidence. If I could look at that, that would be helpful. State's Exhibit 7. I'll get my calculator. The checks reflected on State's Exhibit 7 totaling $1,289,593.51 are checks that actually were written on your attorney-at-law escrow account. Those, and in doing that, I was reconciling to the amount of money that you had actually received as per my examination. And the difference between what you wrote out and what came into the account was $900 difference. That indicates that all the money that came in with relation to this also went out. And I established what went out through the information and testimony you provided in the Chancery Court. You actually handed us these checks that had been written on your account, and then I was able to put it together and sort of close the lack of knowledge that I had at that time, and I was then satisfied that the amount of money that had come in to your account, as I was able to determine from the documents in Clarksdale, was almost exactly what you spent out. So those are the type of conclusions that I was able to reach. You can't always have perfect documentation. You know, those checks nor the bank statements on your escrow account were available from Trustmark because of the passage of time, and I just had to do it by other means and methods. But I am completely satisfied as to the accuracy of my information.
But my question to you is this. Based on the documents you have, that means State Exhibit 2, State Exhibit 9, go to State Exhibit 2, you have no knowledge based on that document when that check, if it did in fact go through my account, did you?
Based solely on State's Exhibit 2, if this was all I had, was this single piece of paper, the answer would be yes. But because I have all this other information available to me, the answer is no.
I think you got that reversed. But we'll move on. What I'm asking you is pretty simple. Pretty simple. You don't have any knowledge when this check was deposited, correct?
I've got to check.
Sustain. Back up to the podium, Mr. Brown, unless you go further to.
You don't have any knowledge how these two checks correspond to each other, do you? That's State Exhibit 2, State Exhibit 9.
They're different bank accounts.
Okay, what I'm asking you is, based on Exhibit 2 and Exhibit 9, that's the $300,000 check that was written to Shackelford, you have no idea if that $1 million check was in my account when that $300,000 check was written to you, based on those documentations.
Again, if all I had to look at is these two documents, Exhibit 2 and 9, I couldn't tell you where this money came from, what it was for. I couldn't tell you anything about it looking solely at Exhibits 2 and 9 beyond what it says on the face of the documents. But because of all of the other information available to me, I can safely and conclude with a high level of confidence that this $1 million represented by this check went into your attorney-at-law escrow account at Trustmark Bank shortly after February the 20th, 2001. On February the 22nd, 2001, you wrote a check on that account for $300,000. So I would say that it came into your account either on February 21st or 22nd, 2001.
Okay. What I'm asking is, you don't have any document, bank statement, that shows that. You're just making a random assumption, correct?
Hang on. What's the objection?
Repetitious.
Been asked and answered, Mr. Brown. Objection sustained. Let's move.
Let's go on with this. On this document is marked as State Exhibit 1. You see that State Exhibit 1?
I did.
Show me where I got $300,000 from Tom Ross and dispersed it.
Well, that's not actually reflected on State Exhibit 1 is a summary which reflects that on February 20th, 2001, Tom Ross wrote you a check on the Rebecca Henry estate for $1 million, and it was transmitted to you, and that it then cleared the Rebecca Henry estate bank account and was no longer there.
Okay. You stated that if I had gotten $1 million, that's the transaction that I should have put into a guardianship account, correct?
Yes.
So if you're talking about me doing anything wrong, it would be the $1 million check, correct?
That would be one thing that was done wrong.
Your allegation.
Pardon?
Your allegation, you're saying that check should have been deposited in the guardianship account.
It should have been, yes.
I'm asking you where I get that $300,000 check from Tom Ross, write that check for everything. You don't know that $300,000 come from here.
Mr. Brown, there's about 4 questions in there. Please limit it to one question at a time. Ask another question.
On that document, you have State Exhibit 1. You do not see the check that was check number 1152 from me, marked as State Exhibit 9. You do not see that $300,000, do you, on State Exhibit 1?
It's not supposed to be there. If it were on there, it would be bad out of place. It's not intended to show that.
What I'm asking you simply is, I didn't get a separate check for $300,000 from Tom Ross, correct?
No,
I got a check for $1 million, one check, correct?
that is correct.
Okay, but would it be safe to say that you're saying that my bad act, if there is a bad act, was that I took that $1 million check and put it in my escrow account?
You're not saying you did.
Well, I'm going to overrule it. I'm going to let him answer the question.
No, there is absolutely nothing wrong with you putting that $1 million check into your client escrow account if it just made a short stop there on its way to Devon's account at Trustmark National Bank. There would be no logical reason that you shouldn't have taken that straight to the bank. But if you ran it through your trust account, deposited it and then redeposited it, there would be, while it might be a technical error, there would be no wrongdoing in my mind.
Well, what I'm asking you is, I never got a $300,000 check from Tom Ross, correct?
No one ever. I never said that you got a $300,000 check from Tom Ross. I said you got a $1 million check from the estate of Rebecca Henry that was sent to you by Tom Ross.
But you have no proof to know where that funds came out for that $300,000 to go for that check, do you? There is no bank statement. That's what I'm saying. I'm just plain simple. There is no bank statement, is there?
There is no bank statement for your attorney-at-law escrow account for the month of February 2001. You testified in court that you had a flood in your office, and those records were destroyed in the flood.
Okay, and we could try to get the records from the bank, but it was too late. They waited too late to do this, correct?
That's my understanding, that the bank didn't keep records after 7 years.
And you understand from looking at all this stuff, if in 2005 or 2006 these allegations had been brought forth, I would have been able to produce bank statements, correct?
I don't know when you lost them, and I don't know whether the bank had them or not. Based on the information that I learned, you should have been able to get them from the bank.
In 2006, correct?
Correct.
Okay, even up to 2009, I would have been able to get the bank statements, correct?
I don't know that. They said 7 years, and this was 2001, so 2008 would be 7 years.
So, based on the fact that this state had been closed back in 2006, correct? You look back at the documents, you saw the state had been closed, correct?
It had been closed, yes.
And you saw that Russ Russell had wrote a next of friend petition, correct?
I believe I do remember seeing that, yes, sir.
And in that position, he wrote about that $300,000 check, didn't he?
I would have to see it in front of me, but if you say he did, I wouldn't disagree. It would be logical that he would have included that.
Subsequent to that, Judge Robinson closed the estate, correct? Closed the guardianship.
I'm not sure about the time sequence, and whether it was subsequent. I don't know. I don't have the dates committed to memory.
Russ Russell testified, didn't he?
I don't have the dates committed to memory.
In that deposition, in that transcript, Russ Russell testified in that transcript also, didn't he?
I believe Mr. Russell did testify, but again, insofar as the sequence of events all those years ago, I don't have those committed to memory.
Okay. And you notice that the state exhibit A. What is that?
That is a check on Michael J. Brown attorney-at-law escrow account dated September 7, 2001, payable to Linus Shackelford in the amount of $250,000. The memo line says loan secured by something and Rankin County something, Lakeland Place. I can't make out this. You're writing, but I can't make out all the words. But it's indicating that this check was a loan secured by something, loaned to Linus Shackelford in the amount of $250,000. And I assume the check mark at the bottom is your signature. That's the one that I've seen on the other checks.
Is that check, do you see a writing thing there that shows that check cleared?
I do. I see that it was. I have a photocopy of the front and the back of the original check, apparently, and it is endorsed by Linus Shackelford and Commemorative Properties LLC. Shows that it was paid by AmSouth Bank, which is, I assume, where he banked and deposited that. And then on the front it shows that it cleared for $250,000.
Again, if you look at State Exhibit 1.
Yes, sir.
State Exhibit 1 showing where I received $250,000 from Tom Ross and dispersed it to Mr. Shackelford.
Well, that's not the purpose of it. The purpose of Exhibit 1 is not to show that information. It's not on here.
So I never received a check from Tom Ross for $250,000.
Your Honor, I object to that. That's not a question. And I do object. It's not proper.
you're in a way to argue with Mr. Brown, ask a question so that he can answer it.
All right, so that's what I said. Does it show everything on there that I received the check from Mr. Ross for $250,000?
No, it does not. But it's not supposed to.
Why is it not supposed to?
Well, the title of the document is Guardianship Funds Delivered to Michael J. Brown. It's not checks to Michael J. Brown from Tom Ross.
Well, I was asking you was, did I receive any more checks than that $1 million check?
From Tom Ross?
All right.
Tom Ross was the attorney for the estate of Rebecca Henry. Mr. Ross was the conduit through which checks from that estate were delivered to Demond McClinton, who was a beneficiary of that estate. He sent those checks to you as the attorney for Demond's guardianship.
You talked about that you got a search warrant to search my house, correct?
The search warrant was issued for your house, yes, sir. And I did accompany the sheriff's deputies when they went to execute that search warrant.
And you looked for documents and things?
I did, yes, sir.
Yeah. And you looked pretty thoroughly through my house, correct?
I would, I looked pretty thoroughly through the room that I was supposed to be looking in, which was the one designated as your office that had client records, a number of Chancery Court files that you had checked out and never taken back. There were boxes and boxes of your personal records that were made, your personal and client records. That was really the only room that I searched through. Other people searched other rooms, but that's the one I concentrated on.
But there was a computer down there, correct?
I don't remember if there was, I don't deny there was a computer, but I didn't get a computer.
When you were searching my stuff, you never decided to take a computer at all?
No, sir.
Okay. And you found some volumes of records of work I had done, stuff on the sale of Channel 3 and everything like that.
I saw there were lots of documents relating to the Henry estates, yes, sir.
In regards to all that. And you saw my office was pretty well tore up.
It was in a significant state of disorganization when we walked in.
Looked like checks was all over the place, wasn't it?
I wouldn't say that, no.
Well, did it appear to you that someone was looking for checks when you looked in the office, that someone was looking for something?
I couldn't say that. I mean, it was in such a state of disarray, it would be hard to say what anybody had been doing.
Never mind, Your Honor.
All right. Any other questions? This witness, Mr. Brown.
No, Your Honor. Let me make sure I get all the exhibits back.